All right, we'll go ahead and get started. Sure, there are a few more people on their way, but it is 12:15, so. So those of you who are fellow anteaters like me already know this presenter today, Professor Bob Solomon. He taught me evidence, and many of you as well. And he's going to be here today talking to us about introducing and authenticating documentary evidence, especially digital evidence, which is something that you guys know we deal with all the time. Text messages, social media postings, this comes up regularly, and some people, including the county, are a little bit sloppy when it comes to the rules of evidence in terms of actually getting it in. So we're going to go into a little more depth learning how to do that. So, Professor Solomon, thank you so much.
Thanks, Amy. Nice to be here. Thanks for inviting me. This is your time, so feel free to yell out questions, and if you have any issues, don't be shy. I'm not, but I would like to try to produce what you would like to see. So I wrote the biographical note because the Morgenstern article, which has been updated, is online, and I gave you the link. Hopefully it works. It might not off of this, but it's not hard to find, and it seems to be the most comprehensive review of California law. And at least when I started, I relied on it heavily. I think it's a little confusing in parts, but it's basically, as far as I can tell, the best source. And the second bullet point is really important, because when people think about digital or electronic evidence, we start from the notion that it's new and it's different. And courts started the same way. How do we deal with this? And if you go back even a few years, you find courts saying, well, it's too unreliable. Because remember, whenever we're admitting evidence, we're concerned that it is reliable, or in the case of anything in writing in California and elsewhere, whether the document is what it purports to be. I'm going to say that over and over again because I really believe in repetition when it comes to evidence. I meant to start by saying my evidence class is taking the final as we speak. So, yeah, so it is conceivable I will get a freaked out emergency call from the dean of the dean, but probably not. But if I do, I apologize. Having started there, courts now have come, I'm going to say full circle, and we are starting to look at digital and electronic evidence the same way we look at other pictures, videos, and other evidence, in that we are not creating new rules and new standards. We are moving back to the old rules, primarily 1400 in California. I mentioned Federal Rule of Evidence 901, because 901 is particularly good in giving you examples of how to get things admitted. And so even if we're talking about California law, it's pretty much identical in most ways, and I think looking at 901 and taking the examples is a good place to start. So, 1400A is foundation, and years ago when I first started teaching evidence, either Amy's year or a year after, that summer I had a student who was working in the district attorney's office in Orange County call me and say, Professor Solomon, you know all that stuff you talk about foundation? It turns out it's really important. So yeah, it's really important, and every question, as you all know, has to, in theory, have a foundation. We often skip this because a lot of it is assumed, but you cannot assume foundation when there's a question of authenticity. It is all about laying the proper foundation. So I have something that's not quite true, because I say it is not about relevance or reliability of the information, hearsay, but about laying the proper foundation to answer one question. Is the writing what the proponent says it is? And the definition of writing is extraordinarily broad. Think of it as anything other than spoken word. Anything other than oral word is going to be considered a writing, and I give you the case, but basically that is law. The reason I say it's not entirely true when I teach this in evidence, we're teaching federal law, and I start by saying every question, every piece of evidence has to be relevant. So you start with relevance, and only then do you move on to the question of authentication. California courts are treating whether it's authentic or not as part of relevance. I don't think that makes any particular difference, but it's a little idiosyncrasy that it is not relevant unless it is authenticated. It doesn't matter that the information in the document may be relevant. We are not going to get past the relevance question until we authenticate it. So what does all that mean? Well, first of all, we are allowing circumstantial evidence. I'm going to come back to this a little bit, but it's probably worth mentioning the Supreme Court case, which is People versus Goldsmith, and it's cited in here, but I'll leave you this copy. And I'm just reading a couple things from page 8. The first step is to determine the purpose for which the evidence is being offered. And I'm going to get back to that when we talk about hearsay. The purpose of the evidence will determine what must be shown for authentication, which may vary from case to case. The foundation requires that there be sufficient evidence for a trier of fact to find that the writing is what it purports to be, that it is a genuine for the purpose offered. And they cite People v. Valdez, and People v. Valdez is the most important case here, and I'll come back to that in a minute. So, the fact that we authenticate a document, even through circumstantial evidence, does not answer the hearsay question. There is often going to be hearsay within the document, and that hearsay is not admitted merely because the document is authenticated. And you're going to run into this all the time. I'm sure you all have, and I'm probably saying something you all know already. But let's take the case of Valdez, which was a MySpace page. And in Valdez, the prosecution offered a lot of evidence that Valdez was a gang member, and they particularly showed his MySpace page, and there was all kinds of pictures. It was password protected. All of these facts are part of the circumstances by which the court determines it is authenticated. We have enough evidence to determine that Valdez is the owner of this site, or at least place the pictures on. Now, what did it include? It included pictures of Valdez, a lot of pictures. It included, gang signs, supposedly. And you all know how all of this plays out. And it included some grandiose statements. The world is afraid of us, with gang initials. And the way the court got around what seems to be obvious hearsay is to say it's not being offered for the truth. It is being offered rather to show the conclusion through all these circumstances that he is a gang member. So we don't have to address the hearsay question. We have to address the question of, is it authentic, and is there enough circumstantial evidence to say that he is the owner of this particular page? And remember, the standard is fairly low. The standard is going to be, is there enough evidence, circumstantial or otherwise, for a reasonable fact finder to infer the fact that for which we're trying to offer this. And so this was not offered for any hearsay within the document. This was offered to show the conclusion that there's a lot of circumstantial evidence that Valdez was a gang member. Well, that's a pretty big push in my view, and I'm sure you're all on the other side thinking that's not particularly fair. I'm going to say it's a bunch of crap, and it pretty much is, except that you are going to need to try to fight each little piece of hearsay one at a time. And I know you have particularized and difficult hearsay rules in the work you do, and that makes it a lot harder. But merely having the document qualified, authenticated, means it gets into evidence. It doesn't mean hearsay within the document is admissible. Okay, so here's Valdez, and it basically says circumstantial evidence is the standard for authentication. The MySpace page icon identified him. It showed his face. Yes, that is circumstantial evidence that he has control over it. I mentioned the gang signal. The important part is that the court said that the contents of the document itself can be used to authenticate the document. And in this case, there was very little more other than the contents of the document itself. There was someone who testified that the username was a name he often went by, and there were a lot of pictures of him, and so there were reasonable things. And so there you see the conclusion. A reasonable trier of fact could conclude from the posting of personal photographs, communications, details, password protection is very important in these cases, that the page belonged to the defendant. And this is the standard that comes up over and over again when we talk about texts, when we talk about other social media, when we talk about emails. Do we have this kind of circumstantial evidence? So Goldsmith cites Valdez with approval, and Goldsmith is the Supreme Court case. It liberalizes admission, so it's pretty interesting. Goldsmith involves a picture taken at a red light, at a camera picture taken at a red light stop, so no one is taking the picture. And at the trial court level, there was a question of whether or not in California you need the person who takes the picture in order to admit it. That's an odd question in federal law. In federal law, at least when I teach it, we always say you need to show, I'm showing you a document, is this a true and accurate depiction of the scene as it occurred on that day? And that's enough. Well, and there is a case prior to Goldsmith that held that was not enough, and you need to have more evidence about the mechanics of taking the picture. To the extent that was the law, and it's hard to say whether it was, because Goldsmith cites cases before, I think it's Becker, but that it is now, we now have conformance between federal law and state law. It is enough to say, is this a fair and accurate depiction? That doesn't answer the authentication question in this case, because what are we concerned about? We don't know how this picture was taken, except it happens mechanically. You go through a red light and suddenly there's a picture. We were in Colorado, and I was closing my eyes in the car, and I suddenly hear my wife say, "Oh shit," because she went through a red light and saw the flash of the camera. And yes, we did get a ticket, and we did not go back to Colorado to contest the ticket. So I don't know what Colorado law is, but I know that in California, I might not have known this for California were I not here today, but I know that in California our standard is that we are not going to require for authentication that there be a showing that the mechanics worked properly. That's a really important proposition. And in your case, you might have, this is a picture from a camera, but you're also dealing all the time with computer-generated information. And the court has held, in Goldsmith, they talk about this, and other California courts have held, it is our policy not to look into the hardware or software capacity. Yes, you can argue that, but it's a matter for cross-examination. It is not part of authentication. And that is, as far as I can tell, pretty much absolute in California, that you cannot voir dire or challenge authentication because of problems or possible errors in the hardware or software. You need to cross-examine. And again, we have confirmation that any circumstantial evidence, content, location, or the catch-all, anything else. What is the court looking for? The court is looking for one thing, I know I'm saying it over and over, is this document what the proponent says it is? And as long as we can show that, then you're going to get admission. So how do we authenticate it? Well, we can have a witness who saw the document prepared. Now, when we talk about seeing the document prepared, we're also talking about, I was with him when he texted this. I saw the text. I saw him post the picture. I was with him. He told me to check his MySpace page and to see where he would be. And I went and he was there. That's circumstantial evidence that I followed what it said. Handwriting, there's lots of ways to show handwriting. 901 is a great example. You can have handwriting shown by someone. Have you seen his handwriting in the past? Yes, I have. You think you could recognize it? Yes, I do. Is this it? Yep. Good enough. So that's an easy one. You can also bring in handwriting experts, which we don't see too often. But the weird part is you can actually say to a fact finder, here's the document with the handwriting, and here's another copy of his handwriting. Match them up, and you'll see they're the same. I think that's a little weird. You can do that in juries, with jury trials. That's an odd way to do it, but we can do that. So there's lots of ways. Why? Because that's considered reliable enough, because everything else is left for cross-examination. We're not talking about a high standard. You all probably know official records, and you run into this all the time. There's a presumption of genuineness with official records, and then the catch-all. Any other way to show the writing is what you say it is. So, emails, there's a lot of ways to meet the burden. The burden is probably in your line of work. Yeah, I'm sorry.
Sorry, I had a question back on the last slide.
Yeah.
So with, if you're showing...
This is a great clicker.
Yeah, with handwriting that like one signature compared to the other is one way to authenticate it. So if we had like an enrollment letter from a parent's enrollment into a therapy program, and that had been already verified by the social worker, so there was no question as to the authenticity of that original document. And then they come to court the day of the hearing and submit a progress letter that has an identical signature. Can the comparison of those?
Yes.
So that's
a perfect example. Yes. In federal court, you can say to the jury, look at these two documents. You gave the perfect example, because the key is to have one that we've established, usually by admission. Yes, I wrote that letter. And then you're matching up. And any way that the court feels is reliable is going to be sufficient. And guess what? Most judges think if they're the ones doing it, it's super reliable. I don't know if we have this phrase. When I was in California, when I was in Connecticut, we always talked about black road disease. Is that a common phrase? No? That there's lawyers who are perfectly reasonable and then they get black road disease. This is a disease where what?
Valdez.
Okay. That's a good one. I want to learn the local. Yeah, some of you'd have a perfectly a friend who becomes a judge. You think, how great, so-and-so's a judge, and then you think, not so great. We have official records and any other way. So, authenticating email. Well, email is really great if you're trying to get an opponent's email in, because it's dated, it's usually accurate. The reason why courts are nervous about email is the obvious one. Anyone who has the computer, right, you're nodding. Why don't you tell us your story? There's a story. No, there's always a story. Anyone who has a computer can hack in, and you don't even have to hack in. Someone leaves it open and you type a message. Periodically, I get a message from my wife that's really written by my daughter. She thinks that's a hysterical joke. Not so funny. We had I shouldn't even, we have an admissions issue years ago at UCI where someone had hacked into a teacher's email and written all kinds of really bad stuff to the students, to his friends who were in the class. So we all know stories like this. So you have to be able to show that it is reliable, and it is not enough to say, I got an email with this address. You should need to show more. I hesitate because, as we all know, we could talk about what the hearsay rule is. It doesn't mean judges understand the hearsay rule, because many of them don't. And we've all known judges who have their own little hearsay rule. And that's the problem, but it's nice to know what the hearsay rule is in the court you're standing in. But generally, you're going to need to show more. So there's a whole list here. Chain of custody is one and again, it's sometimes hard to show someone had custody of a computer, but if I send it from this, it's going to be pretty easy to show this is with me all the time. I don't tend to leave it around. It is password protected, not a very sophisticated password, but still a password. And yes, other people can conceivably get control of it. But if you ask me how I use my phone and where it is, you are probably going to produce enough evidence to show I am the one in control of this. And if I sent an email, if there is an email from my phone, it is likely to be me. Now, can you contest this? Of course. I can get up on the stand and I can give my own testimony as to why this is not me, why it's someone else, how I was negligent with the phone. The point is, that's for cross-examination and for testimony. It's not a question of admissibility. The standard for admissibility is have you provided sufficient information so a court can rely that this is an email, what it purports to be, is an email from me. So, I'm really talking about evidence showing control of the account, but there's also contents only I would know. And that, of course, is circumstantial evidence that I am describing something that happened. I was there, other people weren't. I'm describing where I'm going to go, and I show up. I'm describing that I have purchased particular drugs, and when I'm arrested, those drugs are on my person. All that is circumstantial evidence. Should we allow it? I mean, should this document come in? You all know it does, because that's going to be enough for a fact finder to say, I think that is enough. And then the easiest one, it's a reply to something you sent. I sent an email and I asked him his opinion, and he responded in a way that is consistent with our previous discussion, and so it must be him. Well, not necessarily, but yeah, generally it must be him. Pretty easy for someone to walk into my office and get access to my computer and type out an email. And so I can contest that, but if you can show some of these things, then you're going to get it in. Near the bottom of the list, that the sender took action consistent with the email. Let's meet at the pizza place, and then I magically show up at the pizza place. Action consistent with the email. And then if it's obtained from the phone or computer, this of course is when someone seizes my phone and they have access to my entire life, and it is going to be hard for me to deny that that was mine. So, chat room conversations are particularly difficult. I don't know if you run into chat room conversations. Okay. Yeah, I mean, it's like, why are you writing that on social media? I know it's like, what? I know you all have cases where you all hear the facts and you say, what were you thinking? Or what do you mean? I once had this was a law student years ago who crawled out on a third-floor window in order to peek in his former girlfriend's window, and you can imagine why. And I said, why would you do such a thing? And he said, oh, I had to. And the answer to that is, well, no, you didn't. But now you're stuck with it. You now own that you're crawling on a third floor window to look into someone's window. And so, yeah, we all like to write great stuff on social, well, not we all don't, but I have 3 children, 23 and below, and they, God knows what they're writing. I got on Facebook so I could follow what they said, but of course, you know, it's like, okay, we won't use Facebook anymore. So I don't know what they're doing. But you've all had that, and chat room conversations are really a problem. Often, the way you can attack a chat room conversation is that someone has done a summary or a cut and paste, but not an actual screenshot. If it is not an actual screenshot, you have a great opportunity to challenge this as not reliable. Why? Because obviously you can make whatever changes you want, you can edit it. And the court's job is not to determine whether or not someone edited it, but whether or not the process, how we got here, is that reliable. It is very easy to take a screenshot, and if you cut and paste, or you take a portion, or you edit it, that should not be good enough. That is a reason to contest it. It's always great when you're talking and you get to a point where everyone writes something down. Oh, this is a good one. I'll keep talking about this one. So that's really a problem, and I'm sure it happens all the time. By the way, California does not have what is unfortunately called the best evidence rule. Federal court still has what is called the best evidence rule, but in fact California and federal courts both use what is called secondary evidence. And what that really means is, instead of an original, you can have a copy. That's all it means, as long as it is an accurate copy. So that's just because of the modern world. The notion of a copy, when I started practicing law, 100 years ago, was that we had carbon copies. Believe it or not, we would type briefs, and there would be carbons. And you know how what are carbons? I used to have a quill. I had my own personal quill, and that was very useful. A little pot of ink, and when we, how you make last-minute changes in pleadings, we would have to do that by white out and making it, there'd be like 3 lines that were blank in the middle of the brief. Yeah, this is true. And this wasn't because we were incompetent. We may have been, but it was because there was no other way to make a last-minute change, because nothing was computerized, and people typed all day. But times have changed, and we now think that copies are pretty good, and we send stuff electronically all the time. People buy houses without ever showing up. It used to be the signature on a deed was sacrosanct. It had to be wet. You had to be there. It had to be notarized. All that's gone. New era, great. But what that means is we now have the secondary evidence rule, which really can be summed up as a verifiable copy is as good as the original. And what do we mean by verifiable? All the stuff I'm talking about. We mean enough evidence to show that it is what it purports to be, that this copy is a copy of the original. And if you take anything other than a screenshot from a chat room, it is not a verifiable copy. It is something you created by yourself. It should not be properly, in my view, it cannot be properly authenticated. I keep hedging because I know you all have judges who will find a way to get it in. But you have a reasonable right to appeal on that ground, or to argue on that ground. So, that said, chat rooms, you all know, everyone uses their own little name, and it is legitimate circumstantial evidence to have a third party say he uses this screen name. So when we talk about circumstantial evidence, that is valid. His password is. So, I don't know if you all have passwords that other people know. Sadly, lots of people know mine. either in my office or in my family, so they could testify as to what my password is. The content identifies the sender. You will notice we are being repetitive. This is the same standard that we said in other areas. But it is content that you're talking about and things, and you do show up, or you have a picture of yourself. People have pictures of the proceeds of their crime. Why do people do that? Because people do that. People videotape their crime and post it. And, yeah, it's odd. But you have more contact with this than I do. There's contact information given by the sender to other users, contacts by which you can identify. If you want to reach me outside of this room, email me at, and it's an accurate address. Circumstantial evidence, enough. We're talking about how many balls you can juggle at one time. How much can you keep in the air? No one element is necessary enough, but the compilation of circumstantial evidence builds on itself over and over again. And again, evidence on your own computer, that includes the screen name that you have. How am I doing? Pretty good. Okay, so social media postings, we're really talking about the same thing, but it is critical, again, this is what I just said, critical to preserve the posting in its original state. Screenshot, yes. Secondary evidence rule, copy. Oral testimony, no. A summation in writing, no. You must have the original. Again, it's usually circumstantial. It can be a posting taken directly from the phone or computer. It can be testimony from the person posting. Yeah.
That covers like text messaging.
Yes.
Because my clients always have text messages.
Yes.
They'll show me something, but I can't see the context, where it fits into the thread or the
yes.
scheme. And so I really don't know how to present from their phone to the judge.
It's hard because they are presumably admitting that this was their phone and they had access to it and no one else did.
Well, usually it's the other party that
yeah, well, but if you want to prevent it, you're going to have to argue against these things. You could ask to voir dire and see someone else had access to the phone. It's not password protected. But if the answer is going to be, I was just kidding, then that's not going to prevent admissibility. Just kidding is not a good question for authentication. It has to be, to authenticate it has to be someone who wasn't kidding. That's not the rule. The rule is this an authentic copy of what he said? Does this purport to be the actual series of text messages that were sent? And yeah, usually it is. So you're usually in the position of cross-examining or your client testifying as to intent. But that does not prevent admission.
So when authenticating, I think I'm getting ahead of myself with text messages, but when someone sends
there is no ahead or back here, I'm just babbling on.
When you're trying to authenticate a text message that was sent, for instance, from a different parent to your client, you would need, if you were going to have the person sending testify, you would have to have the parent that allegedly sent that text message authenticated.
Not necessarily. You have so here's the distinction between hearsay and authentication. You may be able to authenticate a whole line, a whole thread, because what you are showing is that this really is the thread. I sent it, there's a response. So the response may be hearsay, but I may be able to authenticate it as the real thing. Because if I have an exchange with Amy that goes back, we had, before I came here, we probably had 4 emails back and forth. My friend Emily is in the back. We had 3 or 4 emails back and forth. And the fact of the consistency of all that, and we showed up, we're all here, is evidence that those email threads were authentic. And so we can authenticate it. But Emily's email to me is still hearsay. And so I can object. Amy's email to me is still hearsay, and so I can object. And so you need, for that to come in, you need to have a hearsay exception. Or, you know, if it's from your client, you got a problem because you got a party. And if it's a party admission, it's coming in. And I did my evidence review yesterday, and I said, listen to what I'm telling you. If a party said it, they own it. It's coming in. There's even cases where parties said things that they really had no personal knowledge of, that they heard and they repeat, and that comes in against them. You say it, you own it. You know, if you were wrong, you get up on the stand and you explain it's wrong. And if you don't want to get up on the stand, it sits there. But that's a problem with parties. But anyone else, the hearsay objection is there. It's a real objection, and it's important. So it is not enough in a thread to just say it comes in because it's authenticated, because that only goes to relevance. If it's relevant and it's authenticated, you still have every other objection existing. And I'm talking hearsay because that's the one you run into all the time. Okay, so we do have chain of custody, we do have testimony, all these are repetitive information, the sender, only the sender would know. By the way, these things keep being repeated in the cases. Everyone repeats these, and again, it's Valdez. You know, you have a really damaging post and you have your picture on it. That's not a good idea. But that's pretty important in evidence. Who else would put? But of course, anyone could put someone else's picture on. Okay, so authenticating websites. We had an interesting case last week. Witness observation can be enough. I saw the website. Here's what it said. This is a true and accurate depiction of the website, and that can be enough. Here it was a case where in Re KB, so you know that's a juvenile, the police officer laid the foundation by talking about the website, what was on the website. It's very similar to the MySpace situation. I think this is a MySpace thing. And of course, unfortunately, you should not post pictures on your website or your MySpace page of you holding guns and things. That's a bad thing. Especially in this case if you're on probation. Yeah, exactly. If you're on probation and you're not allowed to have any handguns. So that's a problem, and then you're really basically admitting it. And then there's the question of website ownership. Website ownership, however, is interesting. The Federal Communications Act, Section 230, says that a website owner, if it is an interactive website, is not responsible for content. And that may change because people are concerned about human trafficking and websites used for that. There's a really interesting California situation going on right now. I'm sure you all know that we have legalized recreational cannabis, and the big advertiser for cannabis products is Weed Maps. And Weed Maps has a website, and Weed Maps has paid advertising for all kinds of products, and the Bureau of Cannabis Control issued a cease and desist letter to Weed Maps saying you can no longer advertise, you can only accept advertisements for products that are licensed by the state, otherwise they're illegal in California. And Weed Maps said, read Section 230 of the Communications and Decency Act. And so we'll see where all that goes. Congress is looking at this, and as you all know, Congress really acts really quickly. So, so probably nothing will happen, and in about 10 years we'll figure all this out. So website ownership is not necessarily enough. Yeah?
Just a quick question. Let's say you authenticate the website and the pictures come in, but there's no real foundation on the date of the pictures. Let's say it's a probation violation. The guy says he had the guns 5 years ago and he was on probation just last year.
Or it's a toy gun.
Or it's a toy gun.
Yeah.
Then it's just circumstantial?
Well, then it's but if you have authenticated the picture, you're unlikely to keep it out because that's for cross-examination or testimony. So that's where we get into the standard for relevance. It is relevant that he's holding a gun, even if it's a toy gun, because that's something to be contested. And I don't think you will be successful in keeping stuff out on that basis. Does that make sense? Okay. Huh?
Question.
Yeah.
But just following up on that, what about when there's a question as to whether that picture actually represents that person?
Oh, so I think you can challenge authenticity on that. I think you can say this has to be authenticated. It is not relevant if it's a picture of a third party. Remember, we're blending together whether or not we see relevance as a threshold question and authentication as second, or whether we blend them together. It still must be relevant. If you can fight relevance, you keep it out, period. And so the notion that it looks like him, but it's not him, you know, you have a question of how is the judge going to see? Is there enough probative value? Is it material to your issue? It's going to be material because it shows that that someone doing this behavior would be a parole or probation violation. But unless there is enough probative value to show it's that person, I think you have good grounds to keep it out. It absolutely is not relevant, and you need to at least have some evidence it's him. Otherwise, it's meaningless, right? It's Arnold Schwarzenegger. It doesn't count. Okay, text, you know, we've been there already. It's the same. Again, Evidence Code 250 is the section that talks about what is a writing, and take my word, everything's a writing. Unless it's spoken, oral. So texts are very definitely a writing, and it can be, it's the same standard. Here's a case, Stockinger versus Feather River Community College, fairly recent case. Everyone, however, is citing Valdez these days. But in that case, the court specifically says hearsay within the text will be excluded. This is not a free pass on hearsay. And the key, of course, if you want to get it in, is to identify the text to the phone, to the owner of the phone. If you can argue that the phone was lost, used by other people, then you can keep it out. Yeah?
So, following up on that, so if the person, the text chain is coming in and it's authenticated because the person who received it says that this is what they received. But if the other person wants to challenge it, is the only way that they can challenge the fact that those were actually made by them is to testify?
No, I think, because remember I said that it's really the totality of circumstantial evidence, and that someone says, I received it, is not enough, I think, because the courts are saying there has to be, the courts tend to at least include other information. So one example is he did something consistent with these texts, or there were future texts, or I spoke with him after the text, or there is other identifying information, or it's stuff that only he could know. But just to say I received the text under the current law is not enough. Now, some of these things are pretty easy to show. He had exclusive control. It was password protected. There's used a nickname that only he knew. So you need to pile on the circumstantial evidence. With just receipt is generally not going to be enough, but it may if it's a reply to a particularized message or continues to go on.
Thank you.
Yeah.
So to follow up on that, if there is messages being sent to a client that are threatening and harassing, and we want to use them for a restraining order, do you need a response?
No, but you need to show something that it's going to be consistent to show that it came from a particular sender. Something. We're talking circumstantial evidence. They had a fight. This was consistent. There were oral threats before this. You heard from a third party that he's mad at him. Anything that you can add that says this is likely the person. You need to show the fact finder, it came from him, here's why. And so if I were doing this in a court, I would want to make a list ahead of time, every single fact. Say to your client, why do you know it came from him? Here's what happened. Tell me every single reason why you believe it came from him. All of that piles into the circumstantial evidence. It had to be this guy who's threatening my client. Question over here, someone?
I was just going to make a comment. Like, for our purposes, like, sometimes a client will show us, like, you know, screenshots or whatever of the text messages, and it'll say this was sent from Robert at the top, right? So for our purposes, I think it would be easier if we can show just like the telephone number of the person sending it rather than the name, because it's so easy to change a name linked to a phone number on a phone. But once you have the number, our social workers reports usually include the other parent's phone number. I mean, so if the social worker's report is being admitted into evidence, we have like a weird hearsay exception.
You sure do.
Yeah.
I read it and I thought, I must be interpreting this wrong.
Oh no.
You're not. And then I think that that's one way to link, you know, making sure that there is that link, that this person had control over the phone because this is coming from his or her phone number. And then we still have to get over the whole hearsay.
You're absolutely right. And what you're telling me is this is a excellent piece of circumstantial evidence. And so, yeah. That's a great point, that phone numbers are important.
Right, so is it like presumed that if you could show that like in the phone it came from Boo and Boo's number was this number and that in the report is Dad's telephone number, is it presumed that that person had control and they are the ones who have to say I didn't have control of my phone, somebody else had access to it?
Yeah, you're talking about conflicting presumptions because there is a burden to authenticate the text or the document. There is also a presumption, you know, going back to the mailbox rule, there's a presumption that if you put a letter in the mailbox, it gets there. So there is a presumption that if there is a phone number, that if you call my phone number, I have control over that. I think that is a presumption. But I don't want to leave the impression that that is enough to get past authentication. I think you still have to worry about are there other circumstances under which someone else could have access to this phone? So let me ask you a question. Do you all voir dire on these issues or not? Can you?
I just think our judges are that sophisticated.
Well, you know, you don't think the judges are what?
Are that sophisticated
Yeah.
to think of that issue?
Well, okay, but sometimes you make judges sophisticated by insisting that this is my right and I'm going to do it. But you all know your judges, and you all know that there's times when you're willing to fight and times when it's not worth pissing off a judge. I remember saying to a client once, the judge says you should take this deal and it's up to you. I'm not forcing you, but the judge does have a lot of power in this room. And so we all play that game. I mean, I've been doing it for 46 years, and you treat different judges differently, and you know best, and you have a client. But there is a right to voir dire on these issues because this is a judicial decision. It is a preliminary decision, and you have a right to voir dire on the question of whether or not this is authentic or not. Now, it may be that based on the direct, it's so obvious that it's authentic, and you know, police are pretty sophisticated about this too, and so they're using software to identify things, and you know, they have their whole protocol, and if they lose one case, they have a new protocol and they add it. So it's an eternal balancing, but this is an individualized decision. It is an important right. Voir dire is an important right. It's also a great discovery tool along the way. Where am I here? Okay, so I think it's maybe my last slide. So here's ways that you can challenge authenticity. You can argue records were altered, manipulated, damaged. Of course, that someone else has control. But Again, I said it earlier, the reliability of the hardware and software is left for cross-examination. That seems to be a question resolved in California. And as you've all been suggesting, challenging the identity of the author may be your single best approach. Common knowledge, information available to more than one person. We're all going to meet at the pizza place is different than I'll meet you at the pizza place, because if we're all going to meet, it doesn't mean your client was the sender, just one of many people. So looking at the words, we and I are very different. Things that password protected phones and unprotected phones are very different. Who has access to this and who doesn't? There's lots of things where people do as groups and they may all be hanging out. There's lots of friends who know other friends' passwords. These are the kind of questions you have to ask your clients. You have to figure out ways in which you can get to the point where someone else could have done this. You don't have to prove that someone else did do this. You have to prove that the facts are not reliable enough to conclude that your client did it. I think that's my last slide. Oh, I'm always wrong. I'm thinking what I wrote. So this is actually pretty important. So if you want to see the distinction between hearsay and authentication, Remington Investments versus Ramadani is a good one, not too old. And the court talks about operative facts in a way that is not particularly helpful to you. But we are looking at documents and what is the purpose of offering the documents. It goes back to what I said earlier about the question of offering the MySpace page, not to prove the truth, but just to show the totality of circumstances or that something happened. So in Remington Investments, there was an objection to a contract. The contract had been authenticated, and then the opponents say, well, okay, it's authenticated and it's relevant, but it's still hearsay. And the court said it's not being offered for the truth of the contents. It is being offered to show that a contract in fact existed. And so it is an operative fact. Just its existence proves something. In your situation, you are going to need to get away from that. You are going to need to argue that this is not just to show a circumstance. This is actual hearsay. It is actually being offered for the fact of the matter. And I think the notion that there's a picture of a guy with a gun and that's an element of the probation violation, how could that not be being offered for the truth? And so part of what you need to do as part of your trial strategy is going to be, to the extent you can parcel pieces out. Okay, I agree that saying we're the best in the world and everyone's afraid of us, I understand that's not being offered for the truth, Judge. But this picture with the guy holding the gun, it's absolutely being held for the truth. So people who are trying to get these pages in are really going to be fighting for the whole page. And you may be helped a lot by being able to redact some of these more damaging things. Am I out of time?
No, you
No,
got 5 minutes.
5 whole minutes. I'm pretty sure. And of course, you all have the problem. Government records, including those retrieved from a website, can be self-authenticating. And I think that's it. Okay. Yeah.
I have a question.
Yeah, great.
It might be a stupid question.
No, come on.
I'm not really sure.
I might have a stupid answer.
Is there like a burden of proof that because you keep saying they have to prove?
Yes.
That,
They-
so by what standard?
By this, the standard is that the judge has to determine that the fact finder, which of course is himself, which makes it hard, or herself, can conclude a relevant fact. A reasonable fact finder can conclude or infer a reasonable material fact.
So there's not like a
It is-
by preponderance
it is
of the
not a
evidence
pre-
or
well,
prima facie.
It is a preponderance of the evidence, but preponderance that you could reach this. So in other words, taking the evidence in the light most beneficial to the proponent, it still has to meet that, even if you accept that in the best possible light, it still is by a preponderance of the evidence, has to be probative of a material fact.
So, just to kind of summarize today, if I'm trying to exclude
42,
evidence,
no.
right? If I'm trying to exclude evidence,
Yeah.
so my first point of attack is to challenge the authenticity, voir dire if possible. If that fails, hearsay objection.
Yeah, I would
and
say-
possible 352 objection on top of
Yeah,
that.
I would say first, it's not relevant.
Right.
And if you can show any way it's not relevant, even though, as I said, relevance and authenticity blend together. But I think if you can say, we don't even have to get to authenticity. This is not relevant, it's not him. They haven't shown it's him. Then authenticity, and then hearsay or other objections.
Am I missing anything, or?
No, you just showed I could have spoke for 5 minutes. So it's always rewarding to have. I don't mind, yeah.
Well, I have a question, sorry, we're almost out of time. So basically it involves criminal history, printouts, or CLETs. So CLETs aren't certified, like I know if it's certified, it could be authenticated because there's an exception. And I just want to forget about any hearsay exception. Do you think that based on the way the law is developing that that a prosecutor could argue that an unsigned, uncertified CLETS is authentic if it has the birth date of the person that they confirmed from other source, basically via circumstantial evidence. So maybe a birth date, maybe there's some convictions on there that the defendant does admit to, or they get some person to testify, yes, that's his birthday. Do you think that that would be enough?
Yes. I'm sorry.
I'm just
It pains me.
I made
Well-
an objection in our court, and then I was shot down, and I thought you'd be my last witness.
That's disappointed many people. You know, the problem is that we're talking about totality of the circumstances. And you just gave me a totality that said even without a signature, there are lots of facts from which I could conclude it's accurate. And if you think it's not accurate, maybe you can voir dire, but you can certainly deny it later. But here you have, part of what you told me is your client admits to some of the critical facts.
Some,
That's
but not all.
Yeah, well, yeah, that's a tough one.
I have a question. If you want to introduce the document, and you say, is this a correct copy of the text that you received, is that hearsay? Because it's a copy
Well,
of something made out of court.
It's not hearsay because it's a copy, it's hearsay because even the original would be hearsay.
But if the question is this a correct copy versus is this the text?
Yeah, so it is no more hearsay, but it is less authentic. And so the hearsay is the hearsay in either case, but it may be double hearsay. Is it a copy that someone made, or that is it a screenshot?
So how would you ask the question?
I would say, is this an original? Is this a screenshot of the original text, or is this a copy that you prepared from reading the text?
Or would you leave the word copy or screen? Is this?
Well, first of all, you can see by looking at it what it is.
Right.
And so if it's a typed transcript, I would say, this is not the original, is it? This is something you prepared yourself, didn't you? You lying cheat. I would say, objection, Judge. Anyone could produce this. This is not admissible. It's not authenticated. He needs to have even under the secondary evidence rule, he has to have a copy of the real thing. A screenshot is a copy of the real thing. And by the way, this isn't the whole conversation. Is this the whole conversation? This is just what you choose to show us, right? Notice how excited I get even doing it fake. This is great. This is fun. We want to be examining these people.
All right, well, if you don't mind, if anybody
I don't
has
mind.
questions, you're welcome to ask them to, but those of you who have to go to court, I've got your certificates here. Thank you so much.
I said to my wife, I don't think I have an hour to talk, and my wife said, you always have an hour.